Celine, hi, how are you? Welcome to HAQQ. Very happy to have you with us on this podcast. So, I'm an entrepreneur myself. I sign a ton of contracts. And there's always this sneaky little contract that comes at the very end, and it's called dispute resolution clause. And it's the clause that says litigation, arbitration, mediation. Obviously, I know what those are, but if you could give us a crash course and tell us why that clause is very important and your experience with it, that'd be amazing.
Thank you very much, Antoine. Pleasure to be here. Thanks for HAQQ for this opportunity. And I'm glad that you picked on that and that you know the difference between mediation, arbitration, and litigation. So, in my experience, 20 years experience plus in the GCC region, in the industry, we've come across contracts that dispute resolution clause is completely ignored. Private practitioners or even corporate lawyers don't even pay attention to the dispute resolution clause or don't give it enough thought as to how it's supposed to be done and what meets their clients' interest best and how that dispute resolution clause should be read and what forum should be selected. And I believe that it's a crucial point, as you rightfully said. I appreciate that contracting parties at the time of negotiating a contract are looking at the garden being rosy, and for them disputes will not happen, but we need to be realistic, and in some instances disputes do happen. So, as you rightfully said, you have local courts, which is judiciary, and then you have the arbitration as one of the ADR, alternative dispute resolution mechanism, or mediation or adjudication, the likes. Let's focus now on maybe the arbitration clause or the litigation clause. So, when negotiating a contract or drafting that agreement, in my experience and my view, really careful thought should be given to the dispute resolution clause, and some simple checklist questions should be thought of and assessed ahead of proposing even a dispute resolution clause to the counterpart. The first being, are the two parties local parties? Is the contract going to be performed onshore, inland, in Lebanon, for example? If those two questions are yes, okay, we tick 2 out of those boxes. The third question, which is equally very important, is the subject matter of my contract technical, sophisticated? Are we talking, for example, about oil and gas, construction contracts, tech development, pharma, or is just a share sale agreement or a purchase orders, delivery of goods? That's very important as well. Why? Because this will give us the indication, do I need subject area experts to rule on my matter? Or is a judge who is familiar with the laws that will and could rely on experts that are registered with the roster of experts in the jurisdiction?
So basically, subject matter expertise plays a big role.
It really plays a very big role. In my experience and in my view, it plays a very big role.
So if the business is very vanilla or standardized, there's no need for arbitration, but the need for arbitration goes up the more niche or, rare it is, basically.
It's a yes and a no. If it's a domestic contract, parties are here, contract is going to be performed here. If things go south, you will get the judgment, you need to enforce it against parties. Assets are here, that's very important, and I'm going to touch upon that. Then maybe, and speed is not an issue, and confidentiality is not an issue, because local courts are not confidential, whereas arbitration is confidential. So this is the checklist I was referring to. Then you could opt for the courts, although we know that, unfortunately, in this part of the world, sometimes the geopolitical situation impacts on the speed of the process. So local courts could be a good option. They are surely much cheaper than arbitration, and if confidentiality is not an issue, enforcement is not an issue, the area is vanilla or is not vanilla, so, and the parties are here, so local courts could be a good option.
Fantastic. So walk me through it like I'm 5 years old. Okay, what's the difference between an arbitration court and a civil or commercial court?
Perfect.
What's the difference?
Perfect. So an arbitration tribunal, I would call it, I would call it private judge.
Private judge. Private justice?
That's a tricky question. Could be private justice, but within, of course, the ambit of the laws and nothing that contravenes public order. So the selecting an arbitration It means you have the right to select who will be your arbitrators, i.e. the private judges. What does that mean? This means, it doesn't mean that I'm going to go appoint you because I know you and we're good friends and you're going to rule in my favor. Definitely not. But it means when the subject area is sophisticated, when there is a cross-border international trade dispute, when you have to think where I'm going to enforce my judgment/award, domestically or abroad, right? This is where I decide to opt for arbitrators. Arbitration, in your clauses you will say it should be, you should specify the number. You can say 1 arbitrator, 3, 5. It should be an odd number. 5 is not common. Usually it's either 1 or 3. Of course, the recommendation is to go with 3, although it's more expensive. Why? Because as a party in dispute, when things go wrong and you need to have your private judge being appointed and selected, you have a say in who you appoint. And you can appoint people from anywhere in the world. You are not limited with a roster list of arbitration that is, for example, with domestic institutions, because domestic institutions have their list of arbitrators. When it's an ad hoc arbitration, courts have their list of arbitrators that are most of the time local from the national parties. But you could appoint someone that has a very good reputation in an area and international arbitration that is seated in Singapore, in the US, in France, to be your appointed arbitrator. Of course, that person should be neutral and non-conflicted, and of course you would appoint someone that is qualified. If the industry is very tech, or it's construction heavy, you may decide to have a quantity surveyor appointed as an arbitrator. The arbitrator doesn't need to be a lawyer. So we call it the party autonomy. So the counsels of the party will be able to advise their lawyer, their client, actually from the time of drafting the agreement, if things go wrong, how I want to resolve the dispute, which is the better forum, where would I go to court or to arbitration? Arbitration, where shall I have it? Domestic, international? Do I need to put criteria for the tribunal members? Do I need to agree with the other side from now? Sometimes we set criteria in advance in the clause. Do I want my arbitration to be governed by domestic institutions because I'm a Lebanese party, and the other side, will the other side agree? Or is it really an issue if I go to an international arbitration institution? The answer to this question is no, it's not an issue. You will if you opted for arbitration, my advice is always to opt for an institution that has sophisticated up to international standard arbitration rules, but also, most importantly, because sometimes we have very good rules, but the administrative body of the institution is not active or strong enough, or is not really administering and overseeing the processes of the arbitral tribunal in an efficient way. And sometimes you have some institutions who have arbitration courts, for example. And recently, for example, in Dubai, we have, after the new rules in 2022, they have created an arbitration court, like the ICC, like the LCIA. Not all institutions have arbitration courts. So these are criteria that, at the time of drafting an agreement, you need to think of as general counsel or corporate lawyer who is drafting the contract, what would work best for the interest of this case, of the client, and also of the other side. And then you will opt for the arbitration based on that. So to answer your question, it's a private judge that could be from any background that a party wishes that judge to be from anywhere in the world. If it fits the purpose and the interest of the case, that person needs to be definitely qualified, understands the arbitration process and procedures because they are flexible. You need someone, unlike courts, you don't have rigid procedural rules, strict deadlines to file an appeal. It's very flexible. We call it party autonomy and party involvement in the process as well. So someone who is charismatic, who is strong enough to be able to administer the process in an efficient way, while giving the party a say in that process. Because parties want to have a say in that process. This is why they opted for the private court, the private arbitration.
And can I veto someone else's choice for arbitrator?
You can, for conflict reasons, or repeat appointments usually. And this goes back to the applicable law of the seat or the arbitration rules. But usually, like the judges as well, you would look at, for example, when that person is, we call it nominated first, before an appointment. So I suggest someone, the institution write to that person and tells them, you are suggested as a party appointed arbitrator. Please fill a statement of independence and acceptance, and of course he's limited by confidentiality, and provide your detailed CV. In that statement of acceptance and independence, there is a section where disclosure.
Okay.
All rules have the same. Nothing to declare, great. Sometimes they say something to declare, and they will say fill up the sheet. So sometimes you will have someone that would say, and I faced this, by the way, when I was working with Baker McKenzie, because it's a very big law firm, when I had to disclose, I do a conflict check, right? And I have to disclose if I have a hit from, let's say, a colleague of mine in Singapore office who has rendered an opinion to a sister company of the parties, I will disclose, right? So I will say I am conflict-free and available to act. However, when conducting conflict check, it has come to my attention that colleagues from another office have conducted to a sister company some advisory work not related to this dispute. By disclosing this, it doesn't mean that I'm automatically dismissed as an arbitrator, but it could open a kind of comment from the other side. Do you accept her potential appointment as an arbitrator? Do you object, etc.? So the example that I've just given you doesn't automatically disqualify me as an arbitrator. And usually institutions generally in this part of the world apply the IBA rules on conflict of interest. There is a list coded in color.
Very big list.
Very big list.
Very big legal list.
Green, red, yellow, orange list, and then you will see where the disclosure falls.
Okay.
And sometimes as an arbitrator you would say, you know what, let me recuse myself. If the other side is not comfortable with my nomination, I will recuse myself. I will not sit as an arbitrator. Why it's important? Because the arbitration award is final. It's not appealable. Unlike courts. So really, justice and fairness and right of defense of the other side are preserved in each and every procedural process
because it is final.
Because you cannot appeal it.
Is that riskier than the courts? Is there a risk in the finality?
Of course there is a risk, because if you have a tribunal that is appointed that is not up to standard, okay, and that has erred on areas of law, you're stuck with that decision.
Well, can't you just go to the courts?
No. To reopen matters of law, no.
But why not?
Because that's the whole spirit of arbitration. You as a party has decided for an alternative mode of dispute resolution, which is arbitration, that is still perceived in the Arab region, most of the Arab countries, as not an alternative, as an exceptional. Yeah, they even look at it as, you know what, the supremacy goes to the court. You have opted for this. Kind of, you need to be careful what you opted for. This is why selecting the arbitrators from the outset is very important.
Okay.
Having the arbitration ruled by or administered by a proper institution is also equally important.
It sounds very strategic, this whole discussion, because you kind of have to understand where things will go even before you sign that first agreement.
100%.
How much of a role does experience play in this and in picking the right counsel, you know?
A lot, in my mind.
Well, how does it play out, right?
In my mind, when you have a counsel who is experienced, who has seen when the garden is rosy and when things go wrong, right? That counsel, even as a GC, will pick on these things. So will understand that, hang on, things may go wrong. There is a risk, in that transaction, in that deal, and whatever it is. I need to ensure that the rights of my organization are fully protected. And we're seeing more and more very sophisticated general counsels nowadays, right? So the business is growing. Organizations are really investing in strong legal departments and strong GCs, some of which would have had experience in private practice as well and would have seen it. So when you have this type of sophisticated counsel, sometimes that person is challenging you as external legal advisor while drafting the clause. So this is one angle. Another angle, when you have a corporate team working on the transaction, you would expect when you're working with sophisticated law firms that to have a team from all levels involved in this. You wouldn't expect the partner to do all the work from A to Z, right? Unless it's a multi-million transaction and the client is willing to pay those fees.
Not even then.
Not even then, exactly. But also you would expect to have a team starting from maybe intern level to partner level. So I hope that there is no negligence there and you rely on the intern. The intern will not know these things. The intern who has just graduated from school and university, actually, in his mind, arbitration is what is taught in university. And the reality is, as we heard when we had the Beirut arbitration days from prominent professors that I'm proud to say I was their student at one point in time, one of whom has even preached that the curriculum needs to be adapted in universities more, because really the world is moving. We're looking into international trade, international affairs, business, big contractors coming to help us build this country, etc. So you're moving into de facto arbitration becoming an alternative mode of dispute resolution, not an exceptional one.
An established
one. So you need to give the proper education for the lawyers from the level of university when they are graduated, but also from the level of the trainee up to the partner level. So experience counts a lot.
Experience counts a lot. And how much of that just comes down to, seeing a lot of arbitration cases versus seeing exceptional arbitration cases? Because I'm sure there are horror stories when it comes to arbitration.
If we have time, we can talk for days.
Well, let's talk about one.
The horror stories on different angles, Antoine. Horror stories from the horror story of reading the arbitration clause. Let's start with the basic one.
Let's start with the clause.
Let's start with the arbitration clause.
What's an example of a very bad arbitration clause?
I'll give you a couple. First one, when it has both arbitration and court.
Well.
Sometimes you have arbitration and court.
Is it or?
Not or. And. Sometimes it's or. And the or is granted the right to one party rather than the other.
But or is very confusing, no?
Here you go.
Yeah.
Who has the right? And then when you are in a dispute, most of the time, when you reach the level of suing someone, you've reached really a personal vendetta, right? It becomes personal. That dispute really, sometimes really from me sitting as counsel, not as an arbitrator, you try to reason with your client, tell him, but this is strategically, it's gonna drain you, make you pay money, and we're gonna lose. Yes, but the other side is gonna be drained and pay money, and I want to make him suffer. Do it, So you reach that stage. You think the other side is gonna reason with you to say, okay, let's opt for arbitration, not for court. So if you go to this dispute forum, that party is gonna challenge, saying, no, it's the other forum. And you spend months of what we call it jurisdictional challenges to see whether that arbitration clause is valid and which forum has jurisdiction. And sometimes you have two forums that have two jurisdictions. So court is seized, I go to arbitration, you go to court. We're pleading the same thing. Each one determines it has jurisdiction and continues. Maybe at the end one will say, I don't have jurisdiction. But the time and money spent to reach that decision is draining to the client. So that's a very big pitfall. Another clause that we've seen, sometimes there is both, with the right given to one of the parties to elect which one to opt for. We've seen in the UAE, for example, conflicting jurisprudence on this. Sometimes the court have decided, because after having arbitration award, they want to try to evade enforcing it. And you asked me a question whether we can appeal, and I told you on merits, no. But there are some grounds to challenge an award on validity, we call it. Some of these grounds...
On procedural basis,
yes,
right?
And public order consideration and right of defense, etc. And validity of the arbitration clause. So they trigger the validity of the arbitration clause, and they say it's an unfair treatment because the parties were not given equal footing at the time of negotiation. We can argue and say, but that's party autonomy. Those were two sophisticated parties that negotiated a contract and agreed to it. So,
how much of this comes down to a lack of governance on the company's side, on the party's side? I mean, you're telling me about just basic things in the arbitration clause that should be rule number 1 of the playbook.
100%.
But their lawyers aren't pointing it out?
Sometimes their lawyers don't know. Okay. Sometimes they rely on external counsel. It's one of these clauses that is added as copy-paste. Cut and paste from different contracts without thinking it.
GPT lawyers?
Kind of. And sometimes they want to become novel. So they started doing patchwork. And this is even worse. So it is, I would say it's lack of awareness on all fronts, from the corporate external counsel, who has never been experienced and exposed to this and only looks at the transaction at the time of contract negotiation, to a lack of sophisticated general counsel team or no legal team, because some law organizations don't have in-house counsel team. Not all companies are sophisticated enough to have in-house counsel team. So it goes to both. Another example of horror clauses, they've put arbitration and put an arbitration institution that doesn't exist anymore, for example, or mixed, or there is not even a typo. Let's say it's not like that you're saying LIAC BBA, right? And then let's say you've put NS. You say, okay, this is spelling mistake. Sometimes it's a combo. Like, let's say they will say, and the typical example we've seen in Dubai is after the abolishment of the DIFC LCIA arbitration institution in 2022, lack of awareness. Some of the lawyers and law firms and general counsel did not know, right? Not up to speed on what's happening, and then continued putting DIFC LCIA clauses. While the decree that abolished that center institution, it happened overnight. There was no, prep talks, discussions about it. There was announcement, of course. And as you know, no one is supposed to ignore the law, right? So we know this as a general principle everywhere. So parties and lawyers and counsels continued putting the IFC, LCIA after the abolishment of the institution. And then we had cases where, is this clause valid, yes or no? Some arguments were pleaded saying the DIFC LCIA as an institution is inexistent, but the parties intended to go to arbitration. Let's go to LCIA. LCIA is different. Others were pleading, okay, let's go ad hoc arbitration, which is non-institution, because the intention was to go to arbitration. No.
At that point, just go to the judge.
Here you go. And the solution, the outcome was, no, the whole clause is defective, it's null and void, it's inexistent, I go back to the primary authority, which is the court. But how much money and time was spent and wasted until you reach that level from both sides? Plenty.
Quite a lot of money.
Plenty.
Quite a lot of time.
Yeah.
Wow. So, what a horror story, huh?
There are plenty. We can spend the entire day talking about this. And these are real examples. It's not just, something that you can think about. We've seen it. We've seen it in practice.
Let's pick up the pace of the conversation a bit and abstract a bit from the technical, go towards practical advice that you would give different types of companies on different types of transactions and what kind of arbitration or dispute resolution clause they should opt for, right? So let's say tech startup, small business, medium-sized business, large-scale business, different types of transactions, you know them better than I do.
Mm-hmm.
What's the rationale? Where should they go for?
You're trying to take free legal advice, Antoine.
Not for me. Not for me.
I'm joking.
Not for me.
Okay, so tech company, startup. It depends who you're agreeing with. What your agreement is with whom? Customers. So you're providing a service. They need to pay you money. It's a simple transaction.
Okay.
Customers are here in this jurisdiction. If they are in this jurisdiction, they will agree to go to local courts. Cheap.
Okay.
Fast? I'm not sure, but cheap. So you go to that route.
Does the dispute value play a role?
I think it does. And one thing also that plays a role is that are you willing to maybe front load and invest that amount first and then recover it from the arbitration award?
Let's talk real numbers. How much does an arbitration, let's say you and I have a dispute, how much would it cost? Like ballpark figure.
You have different types of costs. You have the cost of the institution, if it's an institutional arbitration, that also encompasses the tribunal's fees. Usually, there is a cost calculator and the institution sets the
fees.
Cost or advance or on cost. It depends on the institutional rules, right?
Okay.
Some institutions, like the LCIA, it's per the hour.
Okay.
And trust me, it's expensive.
It's
because
expensive.
I also sit as an arbitrator with the LCI.
So like, what's the minimum
talking
amount
about-
you've seen? Like, what's the floor? Because you've seen a lot, right? You've seen maybe 100, 200 arbitration cases. What's the floor? What's the bare minimum anyone has ever paid in your experience?
For the institution and the
Total, including
and
legal fees,
and
everything.
the arbitrators, it depends on the claim amount usually, and
Right.
how much complex the case will drag. If you have a lot of jurisdiction challenge, or it's going to be a straightforward case.
Okay.
Legal fees, I would say it depends, because honestly, you cannot talk like we're seeing law firms that pretend to be experts in arbitration.
Okay.
And that go very low, and you will say they have no clue what they're doing. They think it's like in the court. I'm a litigator, I can do arbitration.
No, you can't.
No, you can't, because you might have, and you will likely have, an arbitral tribunal that sometimes not even from the jurisdiction of the applicable law. And you need to guide that tribunal from A to Z. Unlike the courts, when you write to the court a memo, when you read both submissions, you will see that arbitration submissions are very detailed, very sophisticated. You walk the tribunal through everything. First of all, because there is no appeal, so there is no room for error. So you need to ensure that they are not missing anything. You analyze the documents, you analyze the law, you put the case law, you put everything as if you're talking to a baby that has no clue what they're dealing with. In court, it's different, because you are talking to people, to the judges who actually interpret the law and give you the practical application of the law, that they know what they're talking about. So when you tell a court, like, as a set principle of the judiciary, it's 1, 2, 3, they know what you're talking about. I cannot tell the tribunal as a set principle of the judiciary, it is ABC. I need to prove it. I can tell it, I can say it, but I need to sometimes put legal expert opinions to support this position, and case law and translation. So really, you cannot really tell. So we're seeing law firms trespassing and saying we can do arbitration at peanuts.
Celine, I still need the number. What's
Come
the
on.
minimum you've ever seen anyone pay for arbitration? Like, what's the minimum?
If we are representing a client, for example, in real estate, that has a number of disputes on off-plan transaction, and I've had this ages ago after the credit crunch in 2008, right?
Yeah.
So we were presenting 50. So you talk volume, and you don't talk credit. So you would work the first few cases at a loss, because you know that volume-wise, it's going to be almost the same. So we took, for example, fees at the time of, I don't remember. You're going to quote me on this.
I won't. I don't want to know. Time's almost up. I just want to know, as a party, how much am I investing? Like, total.
You're investing, I would say, sometimes between 5% of the value of the claim, and sometimes it can go to 15% of the value of the claim. But if you opt for an institution and you clearly put in your arbitration clause that legal fees are recoverable, this is why I told you you need to be willing to front load the cost. You're going to recover it if you win, or you're going to recover part of it if your claim is winnable 80%. Usually there's apportionment on cost. It's left to the discretion of the tribunal based on the outcome, but definitely you're going to have your cost of filing the claim, right, if you win on that claim, refunded, which is i.e. institution cost and arbitrator cost, and the very big portion of the lawyer's fees being refunded, and the experts if you win on the case. But how are you going to tell me what is winning? Depends on the industry.
Winning is winning, and everyone knows what winning is.
Yeah.
Celine, thank you so much for this amazing episode.
Thank you so much, and thank you for HAQQ, and really I'm very honored to be with you today. And I think this is one of the ways to spread awareness on topics that are as critical as this one.
Thank you. We definitely agree. Thank you.
Thank you, Antoine. Thank you.